litigation as a means to meet the goals and objectives of our clients.
I had an interesting call from a client the other day, and she owns a condominium unit, and she has a tenant who currently resides in the unit, and she has plans to sell the property sometime later this summer. Today is April 22nd, 2020, and we are now in New York in the end of what is, I think, the first month and a couple of weeks of the lockdown or the pause due to the coronavirus and the government's steps to try to flatten the curve. And that's had major impacts on the court systems. Many of you know who are real estate professionals understand that the landlord-tenant courts have been hearing limited cases, and that evictions in large part, commercial and residential, have been basically put on hold, what seems to be like a lifetime for me, but I'm sure for you. So this particular client of mine has goals of selling her unit at the end of the summer. The real estate broker has been trying to get into the property to show it, but the tenants have been reluctant to let people come into the apartment on an open house setting. And we are working through some of those issues with the tenant the best we can. But one of the things that came up during our conversation was how long the tenancy had been in effect and what the terms of the tenancy are and when the lease is set to expire. All very important questions that, as the lawyer, you would want to know with respect to plans to sell the unit, timing, and what kind of lease break situation there may be, or what kind of eviction proceedings may need to be undertaken if in the event the relationship devolves or the tenant gets greedy and decides it wants to stay. Used to be, prior to October of 2019, if you were the landlord and you wanted to raise the rent more than 5%, then you would simply call up your tenant before the lease expired and say, hey, we're looking to renew your lease, but we're going to raise your rent by 5% or over, and the tenant could then take it or leave it without any real written notification on the part of the landlord with respect to this proposed increase. Similarly, if in the event you did not intend to extend the lease term or renew a lease, the landlord would simply reach out to the tenant at any time prior to the expiration of the lease term and figure out if they were going to renew or if the tenant wanted to stay, and these discussions would happen. What the legislature did in New York, which went into effect in October of 2019 as part of the Tenant Protection Act, is that it codified the mechanisms and procedures by which a landlord must now give written notice with respect to tenants in fair market leases. Again, we're not talking about rent stabilized or rent control leases. We're talking about free market leases. In these situations, the government has basically said the landlord is obligated to give written notification to its tenant prior to the expiration of the lease, whether it's going to increase the rent by 5% or whether it is not going to renew or offer the tenant an opportunity to get a new lease for a new term. This is different, and the effects of this could have very big implications for landlords. The legislature now has required landlords to provide 30 days written notice to its tenants if the tenancy has been for less than 1 year, and for leases or tenancies that have been ongoing for 2 years or less. The landlord must now give 60 days written notice if it's going to not offer a new lease or raise the rent by 5% or more. If the tenant had been in the space for more than 2 years, then 90-day notice is required. The implication of this may be substantial in any situation, but let's take our condo owner who rents out her unit and now is looking to have a closing in July of 2020. In such a case, contracts would be out and signed somewhere in April or May, and the tenant whose lease is set to expire on July 1st is now entitled and, as a matter of law, required to receive the written notification from the landlord in advance. If in the event the written notice is not given, then the tenant is entitled to stay in the space beyond the expiration of the term of the lease for the number of days that the notification would have expired. So if the lease was over by its own terms on July 1st, but the landlord didn't give notice of its intent not to renew on June 30th, and the tenant had been there for a year or less, that extra 30 days beyond the end of the lease, that through the end of July, is time that the tenant can legally stay in the apartment without penalty, but under the same terms as the lease that was in effect. It's buying time for the tenant. And this is what the legislature did. It's now your job as the landlord to know your rights and to address and update your procedures. And for all you practitioners out there and professional tenants, now hopefully you're privy to something that you didn't know before. You could use to your advantage or disadvantage. It's up to you. But I'm happy to provide this information to you. Hopefully we'll be out of this pause soon. In the meantime, stay safe, stay at home. I guess we're all trying to get out of the house and do what we can to reclaim much of our lives. But I'm happy to give you this educational tidbit, and I look forward to seeing you on the other side.